Good evening, and thank you for watching PBS Fort Wayne. I think you'll enjoy the next half hour, and I think you're going to learn some things that you might find very valuable in your life ahead. That's what we do here on this show, is to try to provide you with education and information to help you with some of your life choices. Well, tonight our main topic is going to be about probate. What is probate? How does it work? Is it a good thing to try to get out of it? What are the parameters? Well, we have an expert here that can answer those questions for you. You've met him many times here on Life Ahead, and he's an attorney I'd like you to meet if you haven't met him already. This is Troy Kiefer. Nice to have you back, Troy.
Hi, thank you, Sandy. It's very nice to be here.
Good. Well, you heard me say you have to have information and education for our viewers tonight.
Yes.
All right.
And I hope to provide a lot of that.
Okay, and I want to tell you that this is really, Troy and I are sitting here, but it's really your show. So we want to talk about what you want to know, and that's why we have the phone number up on the bottom of the screen. We welcome you to call the number down here and give us a call, ask us your question, and Troy will answer that for you. If you don't mind talking live on the air, that's the best thing. That way, if Troy has a question back, you're still right there on the phone. Otherwise, if you're not comfortable with that, we do have a phone answerer in the control room that will talk to you and take your question and send it out here on the teleprompter for me to read to Troy. So that's another way we can do that. Again, give us a call, 969-2720. Well, until somebody calls, Troy, you have to answer my question.
Oh, okay.
Let's start very simply and give me a layman's definition of probate.
Sure. Probate is the process in which a court will oversee the distribution of a person's assets after they pass away.
Okay.
And there is a public policy reason why we have this. When someone passes away, we don't want there to be some sort of free-for-all with their personal property.
I see.
Yeah, their personal property, their real estate. How does that get passed on to someone else? And so over the years, going all the way back to when the country first started, and even before, it was decided that there was needed to be a process, an orderly process, by which those assets were passed down pursuant to the person's will.
Okay. Okay. As I recall, when we've talked about probate in past shows, Troy, I think that Magistrate Howe told us that this actually originated centuries ago with the Romans, and they actually designated somebody in their long flowing gown and whatever that was the magistrate. So then it means the same thing. They're the person in the Roman days and now that help you make those decisions if you can't come to an agreement. Is that right?
Yes, yeah, and my memory doesn't go back as far as Magistrate Howe.
Well, he's a little older, so he remembers those Roman days.
He was around then, so I'll have to take his word for the Roman implications of probate. But yes, that's their Magistrate Howe is in Allen County, the judicial officer who sits and oversees those probate estates.
Let's play a little bit of what if. What if in my will I don't list specific things that are assets of mine, whether it be a house or a car or lake cottage or wish I had one, What if I don't name those things? Then is it the probate judge that decides who they go to?
Well, actually, the way a will is structured, you start out with specific gifts. So if there's any items of...
You mean that you'd have in your will, that you've listed, or what?
Yeah, so items of personal property, real estate. You would say you want those things to go to specific people. And then after that, a properly structured will say everything that's left over will go to either my children or to charity. So we try and avoid having a property that is not designated in the will. But if it is possible that situation could arise, and if that happens, then those assets are distributed pursuant to Indiana state law.
For example, you don't have to say a specific thing, but so Indiana state law has like a chart or a list of who things would go to if it's not stated in a will?
Yep. Yes, absolutely, that's right. It would go, when a person passes away, part of it would go to their spouse.
Okay.
And part of it would go to their children.
Okay.
So it would be split up, and there's a difference between if it's a first spouse or a subsequent spouse, and whether there are any children.
Yeah.
The distribution percentages are a little bit different. And then, so it's the magistrate's job to make sure that those laws are followed.
Well, what if you don't even have a will, Troy? What's going to happen to your assets and to your property if you haven't named any of those things in a will? You don't have a will.
Yeah, well, one of the things I hear all the time is, I need a will, I want a will, because I don't want everything to go to the state, meaning the state of Indiana.
Sure, yeah.
And that could happen eventually, but that's probably unlikely because that same section of law that I just talked about that says who gets what percentages by default,
right,
if there is no will, will cover that as well. So if there is no will, it'll go to children and the spouse, and then grandchildren. If there aren't any grandchildren, it'll walk back up the family tree until it finds someone who's related. If there really is no one related, then potentially it could go to the state of Indiana, but that's
pretty rare.
It is rare. I've never encountered it.
So it's kind of a myth in a lot of ways that, people will grab on to the worst possible scenario and think that that's going to happen to them.
Right.
Well, okay. Is there a place where I could look that up? I mean, government, or what is it, gov.com or indianagov.com? Is there some place where I could read what that schedule or what that list of things would show in terms of where assets would go?
Yes, and you would have to ask me for a specific citation. I don't have that right off the tip of my tongue. But you would probably the best thing to do would be to Google Indiana Code.
Indiana Code, okay.
And probate, I believe it's Article 29 covers that, and I don't know exactly which
that's pretty specific.
section.
You did know.
Well,
yeah.
I know part of it, but
okay.
Just do a search for no will and Indiana probate, and or
asset distribution, maybe.
Yeah, or you give your attorney a call.
Okay.
And they'd be able to walk you through that as well.
Okay. Okay. Don't forget, we want to answer your questions too here at 969-2720. All right, let's go over the basics, which we've talked about many times, but just to remind people that you need need to have a PR, a personal representative, named in your will. What do they do?
Yeah. Well, in Indiana, we do call that person a personal representative. We used to call that person an executor.
Okay.
And most people are familiar with that term, but if you're a man, you're an executor. If you're a woman, you're an executrix. And
I don't like the sound of that.
Well, neither did the state legislature, so they changed it.
No executrix.
Right.
That's great.
Yeah, so they made it a more modern, gender-neutral term, personal representative.
Okay, personal representative, and they do what?
Well, they would be normally they would be appointed in the will to oversee, under the direction of the court, distribution. So they would be the ones who would go to the bank and collect accounts. They would make sure that all the assets are secure, so that the house is locked up, utilities are paid so the pipes don't freeze. Really just the day-to-day management of the estate. They would, with the help of their attorney, prepare an inventory so you know what the starting point is for the estate. And then they would go all the way through selling real estate, and then finally paying creditors if there are any outstanding bills, and then finally making distribution to the beneficiaries.
Got it.
So
that person representative then, do they tell the court, like, this is where these different assets are going to go?
Mm-hmm.
Okay.
Yes. So typically what would happen, we have supervised estates where the court will take a more active role, but most estates are unsupervised.
Unsupervised, okay.
Yeah, and that's where the attorney would prepare a petition saying this person's passed away, here's their will.
Yes.
Please name the personal representative officially, this person as the personal representative, and that's where Magistrate Houck will sign off on a court order basically.
Approve that person.
Yes.
Okay.
Yep.
We have a question here for you, Troy.
Sure.
And let's see who this is from. This is from Carl. Thank you, Carl, for watching us here tonight. Carl says, what if you were divorced to more than one person and have no will? Would those exes be entitled to money? Good question. And I wouldn't be surprised if that doesn't happen fairly often.
Yes, yeah, that's exactly right. And that is a good question, Carl. State law is pretty clear that if you are no longer married, then your exes are not entitled to anything from your estate. Even if you specifically named your spouse in your will, and then subsequently after that got divorced, then the will not recognize that divorced spouse as receiving anything from the will. Something you do have to pay particular attention to would be non-probate assets, and we may get into that a little bit, but there would be 401ks, IRAs, often life insurance. So you want to double check those to make sure former spouses are not named on those as well, because those will go to exes if they aren't changed.
And I understand that beneficiaries take precedence over what's named in a will. Is that correct? I mean, if somebody, like say they have a beneficiary named on some investment, an IRA or something, but in their will, there's a different person named. It's the one that's the beneficiary that ends up winning.
Yeah, that's exactly right. And the way things pass down would flow in two tracks.
Okay.
So you have the probate track, which would be the will and going through the court, but you also have a non-probate track, and that would be such things as I mentioned, 401ks, IRAs, life insurance. Those are things that if you have named beneficiaries, they will go directly to those beneficiaries without being subject to the will.
Okay, all right, that's good information to share. And we have another caller, Troy. This is Gloria this time, and Gloria, hi, and thank you so much for watching us here on Life Ahead. Here's Gloria's question, Troy. She says, if my parents told their church that they would get some of their estate, but they never put it in writing, would their estate go to probate? Good question. So I'm gathering she's saying that they told somebody at the church, pastor or elders or somebody, that they're going to get some of the estate, but they never put it in writing and they didn't put it in their will. So does that go to a probate judge, or is it settled before?
Well, and that's a good question, and I think it highlights something that people overlook sometimes. If it's not in writing in the will, it didn't happen.
Yeah, I understand that. I mean, somebody can't come up to you, later and say, oh, I'm their second cousin, and they told me they were going to give me $50,000, and they told me that at Thanksgiving dinner. Well, unless it's in writing and they've signed it, there's no proof.
Yeah, that's exactly right. And that may have happened. It would be an awful convenient thing to happen, since that person is not here to say
defend
that
it
did or didn't.
Yeah.
But if that's the only way that the system can really work.
Yeah. Right.
And in that same vein, you can only have one original will. So you sign a will, that is the document that we go by. If a copy of that will is made, that typically is not valid. You can't file that with the court.
Okay.
The reason being that if a will cannot be found, it's assumed to have been destroyed with the intent of revoking it.
I see.
So that's why you really have to keep your will secure, and we typically recommend people leave them with us. That way, things happen, and it's amazing how often a will come up missing if it doesn't happen to treat one person or another the same.
Like all of a sudden, gee, I thought Grandma said she put that in the desk. I don't know what happened to it. Well, there you go. That's a good recommendation for sure. Or maybe you keep a copy where you keep your secure things, but leave a copy at the attorney's office, and there should be no dispute on that. What happens, Troy, if you've changed your will? What do you do? Destroy the first one, or what do you do if you've updated it? Maybe your circumstances have changed.
Yeah, there's a couple of different ways we handle that. Typically, an amendment to a will would be done by a codicil.
Okay.
Where you would make just the specific changes that you would want to make, and then you would put that, sign it, and keep that with the original will.
Okay.
That was much more common when we used to have to type out wills.
Oh, yeah.
Or even I've seen them handwritten. Well, now with computers, we probably, if we prepared your will, still have that will in digital format. We can go and make the changes, and then we usually just have our clients sign a whole new will at that time.
With those changes
with
made.
those changes, right.
Okay, and we have Roxanne on the phone with us tonight. Hi, Roxanne. Roxanne, what's your question for Troy tonight?
Hi.
Hi.
Yeah, it's a little bit complicated, but
Okay.
My mother passed away 10 years ago, and she did have a trust. And in that trust, I also there are two siblings, myself and my older brother. And my brother was named as the first trustee. And he lives in another country and has never come back to Fort Wayne. And now the actual funds were divided. Most of them were through a bank and so forth. So, but I just wondered, it's been 10 years and there's a property involved, and it went to both of us. But is there a length of time that a trust needs to be totally fulfilled and all the paperwork
And
done?
settled, yeah.
Yeah.
Oh,
and
that
I
does
did
sound
it-
complicated, Catherine. Roxanne, I'm so sorry about that. But it sounds like a situation a lot of people might be in where the person, and I was going to ask you about this, what
Yeah.
if the personal trustee or the personal representative isn't doing what they're supposed to do? Or in this case, I think she said 10 years. I think that Roxanne said 10 years.
It was 10 years.
10
yes,
years.
this past May.
Okay, 10 years this past May. So is there a length of time where this has got to be settled and determined?
Yeah. Well, first let me say, Roxanne, this is a very fact-specific case.
Okay.
And I would urge you to speak with an attorney. I'm an attorney, but I'm not your attorney. So I want to make sure we have those boundaries set. And I also want to say that trusts are one of those non-probate assets that we talked about earlier. So they aren't associated with a will or that probate process. And what part of that means is, unless the trust says otherwise, it's really pretty open-ended. Now, the trustee has a fiduciary duty to do what's in the best interest of the beneficiaries, but, and sometimes that means wrapping things up as quickly as possible, but there's no one there like the court to push things along. So things can tend to stretch out. And so I would recommend opening communication with the trustee, try and get things moving. If not, the ultimate relief would be to what they call docket the trust with the court and have the magistrate or judge intervene and be able to move things along for you.
Would he make the decision, or would he just appoint a new personal representative?
Well, in that case, it would be a trustee, potentially if if the trustee was really being negligent in their duties. Perhaps the judge or magistrate certainly could replace them.
Okay.
That's relatively rare. More often, the court would just order them to wrap things up and get things moving along. And if they don't, they could face repercussions with the court. So.
Even though the brother is in another country.
Well, and that gets to the fact-specific situation. That makes it even more complicated. If a person is out of the country or even in another state, there's some question as to which state law applies and which court has jurisdiction. So that's a first hurdle that would have to be overcome in this particular situation.
But I do have sympathy with Roxanne that if this has gone on for 10 years, like you want to get this settled. Okay, good luck with you, Roxanne, and I'd love for you to let us know how that turns out. Catherine, you're on the line now with Troy. What question do you have for him this evening?
I was wondering, my mom is in a nursing home, okay?
Okay.
She's got a son, but he ain't doing his duty or nothing. He haven't come around or nothing. I'm his only daughter, and they can't find him or anything, so they need to be the beneficiaries, him and her son.
Any advice for Catherine on this? She's in a nursing home. They want her to be the beneficiary. But this would take a legal process, right?
Yes. When you say beneficiary, they would depend on if that's a will or some other legal document. And if the mother is incapacitated, if she has dementia or something like that, it would limit what can be done. But it sounds like we'd want to get into more details on this one as well, because it could go a number of different ways depending on the situation and exactly what she's a beneficiary of and who else is in the picture.
And I'm not an attorney, Catherine, but I would recommend you do see an attorney, because this sounds like this could be complicated and you want to make sure it's all done legally correct. Okay, we'll go back to some questions here, but there's still time for you to call with your question at 969-2720. Okay, let's talk about that personal representative. Roxanne mentioned that her brother was living out of the country, and it's been 10 years now trying to get their property settlement defined, if you will. Is it a good idea to make sure your personal representative, formerly executor, live in your state, or could they live in another part of the country? How does that work?
Ideally, you would want that person living in the state and even locally.
Okay.
Because
it's just easier to get things done.
That's right. I mentioned going to the bank, dealing with real estate, dealing with personal property, vehicles. It's really helpful to be in the same community in order to physically do those things. Now, having said that, we're becoming a much more mobile world. We have telecommunications. It's much easier for an out-of-state personal representative to do their job. However, there is one little downside. An out-of-state personal representative most likely will need to post a bond to make sure that they're doing their job according to law. And a bond is basically an insurance policy that if they don't do their job and money comes up missing, then the insurance company will make the estate whole.
Ah, I see. Okay. Okay, a financial question for us here now. Fred has just called, Troy, and Fred's question is creating a will an expensive process? I'm on a fixed income. Big question. Probably a lot of you out there are wondering the same thing. I know we can't give a specific amount because it's going to vary depending on how complex your will is, how many meetings you have to have with the attorney to get that all settled. But is there a rough minimum maximum?
Well,
that's a hard question. I know
really
that's
is.
Almost unfair.
And I mean, it's almost, I mean, I will throw out a range, but I mean, it's so broad that it's practically useless. But it's anywhere from $0 up to several thousand, just depending on the situation. And in fact, we just finished with our Write-A-Will.
Great program.
Right, and that provides wills for free. So those types of opportunities
That's
are
a
out
once
there.
a year opportunity.
Once a year, and I believe usually towards the end of October.
Okay.
And it's advertised in the local media.
Right.
And you would call and sign up, and attorneys volunteer their time in order to help people, such as the caller, prepare their wills.
And what would be at the far end the extreme maximum?
Yeah, we would probably be looking at a couple of $1,000 probably.
Yeah. Okay. All right.
And maybe even 3,000 or 4,000. And you know, you get into situations where you have the upper the 1% of asset owners. They have a lot of tax situations.
Complicated.
It gets complicated, and it quickly grows to being more than just the will.
Got it.
And the will becomes just a part of their
a
overall
part of
estate
settling
plan.
the estate. Okay, again, I know that doesn't give you a specific, but hopefully a little bit of guidance. Well, Troy, you've been wonderful about sharing information on wills and trusts and probate. We hope that you've gained some insight from all of this, and we'll be talking about it again, I'm sure, here on Life Ahead. Meanwhile, I want to appreciate all of you for watching us here this evening, and we'll be on again next Wednesday night. New topic, new guests. Again, for the rest of this evening and the rest of the week, stay healthy and stay safe. Good night.
The preceding program on PBS Fort Wayne was made possible in part by
Beers Mallers, elder law attorneys providing information on legal matters of guardianship and financial issues relating to nursing home care. Beers Mallers attorneys can also assist with Medicaid requirements and help navigate difficult family situations. Offices in Fort Wayne, LaGrange, Warsaw, and online at beersmallers.com.